So welcome to the ACCC. I understand you'll have information on parliamentary privilege and the protection of witnesses. The Senate has resolved that an officer of the Department of the Commonwealth or state shall not be asked to give opinions on matters of policy and should be given reasonable opportunity to refer questions asked of the officer to superior officers or to a minister. This resolution prohibits questions only asking for opinions on matters of policy and does not preclude questions seeking for explanations of policies or factual questions about how they were adopted. Any claim of public interest immunity in terms of answering a question must be made by a minister and accompanied by a statement setting out the basis of the claim. So I'd now like to invite you to state your full name and the capacity in which you appear today, and if your colleague has joined us, then they can do so also.
Thank you, Chair. I'll start. So, name is Nicholas Hees. I'm from the Enforcement Division at the Australian Competition and Consumer Commission.
Okay, Rami Grease, is that right? You can introduce yourself now.
Yes, Chair. Apologies, I was trying to connect. It's Rami Gress, Executive General Manager, Enforcement at the ACCC. And let me apologise from the outset, I've got a terrible lurgy. So,
well, we're glad you're at home.
Which is the reason I'm not in the room with Nick. Thank you.
Which of you is making the opening statement, if any?
Senator, I might just say that we've, I think, made a submission to this committee and are familiar with its terms of reference. We're very happy to assist with any questions that you might have.
Thank you. I might hand over to Senator O'Neill if she's ready, and then I'll pick up some questions after her.
Thank you. Thank you very much, Chair. I'm not sure how much of the evidence that you've heard over the course of these days of inquiry, but hopefully you were here for part of the evidence with the witnesses just before you, the Small Business Ombudsman.
Certainly heard some of that, Senator.
Okay, so one of the questions that I was asking there is about the nature of the power imbalance, and I'm sure that the ACCC has a particular interest in that as well. Can you confirm whether a power imbalance exists or not between franchisors and franchisees?
I might defer to my colleague first, and happy to follow up, Rami, with any points after you.
I mean, while it's difficult to generalise across such a broad sector, I think experience suggests that there is often a power imbalance between franchisors and franchisees in favour of franchisors.
And is that why there have been attempts to create codes to provide some protections for people in that sector?
I think that's definitely correct. Try to correct some of the imbalances and the asymmetries between the two sides.
Thank you.
And I would perhaps also add, Senator, I mean, that was also the introduction of the unconscionable conduct prohibitions under the former Trade Practices Act many, many years ago, and that's incorporation under the Australian consumer law as well, which is really going to the different bargaining power between parties.
I expect there was some resistance to that legislation being brought in by people who were advantaged by the old structure.
It was a number of years ago, Senator, but I think it was something that was closely debated and considered by Parliament with a number of inquiries at that time.
And of course, we have representatives of the franchisors effectively in this sector, the car dealership sector in Australia, who are overseas entities, large companies such as Toyota, who got a very good tick from their dealer network this morning, and then other entities such as Honda, who are not held in such high regard by their franchisees at the moment. Similarly, complainants have put matters to this committee from their interactions with Mitsubishi and with Honda. I think that's rounding out our evidence. Do you believe, not just from the evidence that we've received, but do you believe a power imbalance exists between car manufacturers and car dealers?
I think certainly there are instances that we've seen that suggest that. It would not be appropriate to speak for the whole industry, since we don't have that level of industry knowledge, but certainly in some of our engagement with certainly the Holden dealers, we've observed that imbalance. So
could I ask you to speak on the record about your observations about the Holden matters, because, you know, the matter is now clearly done and dusted, if I can use that term. The decision got made. What were your observations about that, and what was your engagement with that?
Oh, Senator, I need to correct that. We have an active investigation into that issue that's ongoing. I think it's prudent for me not to give any views on a situation that's still evolving.
Right, and the done and dusted is not necessarily for you; it's for the actual franchisees who now have the matter. You know, it dissolved itself on the 30th of June because, despite being told to go and negotiate in good faith, there was no resolution of the matters that were of concern to the franchisees who were selling Holdens in this country for many decades. One of the recommendations that you made to the franchising inquiry in 2018 was to increase the penalties to a maximum of $10 million. Is that correct? And what was the reason for that?
Nick, if you're in a position, you can speak.
I think, Senator, I mean, we've advocated for the increase in penalties, not just under the Australian Consumer Law, but under the Competition and Consumer Act in the past, primarily to ensure that where there is misconduct and the courts find that businesses have contravened the law, there's sufficient penalty for that, but also sufficient deterrence across the sector for other players and other, you know, industry participants, that they will comply with the law going forward. So that has been one of the points that we have pushed, recognising that sometimes penalties need to be sufficient to create that deterrent, particularly when you're talking about larger entities.
So given that recommendation, can you see your recommendation implemented anywhere in the government's action so far?
I think just to note, when we often look at allegations of a breach of an industry code of conduct, what the ACCC often also includes is breaches of the Australian Consumer Law as well. So there, when we are looking at taking any action through the courts, we would also see whether or not there are penalties available, not just for a contravention of the code, but also a contravention of the ACL, which does include those higher penalties. But, you know, I think, you know, at this point in time, the recommendation isn't for penalties in line with what the ACCC recommended or suggested, but there certainly has been an increase in penalties proposed as part of, you know, the reforms to the franchising code.
The proposal, though, has not got legs yet, has it? So your recommendation was not actually acted on by the government, and there is no $10 million penalty against acting in a way that really is unconscionable.
Well, if it's unconscionable, Senator, that would be under the Australian Consumer Law, which would be subject to that $10 million penalty, but for a breach of the code, That's correct.
Okay, so let me ask my question again so it's clearly on the record. As it stands, despite your recommendation in 2018 to increase the penalties to a maximum of $10 million, there is no application of that penalty in the code, the franchising code.
That's correct.
Why did you make the recommendation for such a significant amount? I do note that there's been some efforts to put smaller fines in. Why did you select $10 million and why did you make that particular number the recommendation?
The reason we put forward that suggestion was in line with other penalty provisions under the Competition and Consumer Act and the Australian Consumer Law, that is the current penalty figure in general for contraventions of those laws.
So it's elegant in that it reflects other action. Is it also significant enough to create behavioural change of the kind that penalties are designed to facilitate?
That's certainly our position, Senator, of needs to be a sufficient deterrent to prevent people from engaging in misconduct.
Do you know what the current fine level in the franchising codes are?
Not in front of me, no, Senator. I'm not sure if my colleague does.
No, I know that there are a significant order lower, but I don't have the exact fines to hand.
I have seen them and they're much, much smaller.
Yeah.
I think in a couple of $100,000, it's a very, very different, very, very different scale. Maybe even as low as $60,000.
It's something approximately like that.
You think it's about $60,000?
Something in that vicinity, Senator.
So in your view, you see, because you're the ACCC, you see the practices where people are doing the wrong thing. In your view, is $66,000 adequate to prevent these big players, these multinational car companies, from acting in ways that are against the code?
I think it's hard to... Sorry.
Mr. Griss?
Oh, yes, I'm sorry, Senator. Look, I think the conduct under the ACL is probably the best way to address some of the misconduct that also may contravene the code. So I think whenever you have provisions such as misleading, deceptive conduct and unconscionable conduct, you always have that. You always have that option. So it's often coupled with code breaches.
Okay. Have you seen the capacity to change behaviours when a fine of substance, such as $10 million, is heralded? Have you seen its effectiveness?
I think we certainly have seen instances where businesses, as a result of that, of a significant fine, have changed their behaviour and have introduced broader compliance programs within the company, which has, I think, a benefit in reducing the number of complaints or concerns that certainly come through to us. It also, I think, has an impact on other businesses in an industry who might not be target or, subject to any enforcement action, but they certainly take note of those penalties and in some instances adjust and change their behaviour.
So in the first instance, a significant fine is a corrective for perhaps established practices in a particular industry, but it maintains its place as a deterrent for others.
That's our position, Senator.
In terms of unconscionable conduct, you state that Competition and Consumer Act through the Franchising Code and the ACL requires the manufacturers act in good faith and do not engage in unconscionable conduct, or make any false or misleading representations in its dealings with franchisee dealerships. Have you had the chance to read the submission from Astoria Honda regarding their claims of being intimidated by Honda's chosen firm for negotiation, which is Deloitte?
Have read the submission, Senator, and we've certainly also had a conversation with that individual dealership as well, just to understand the issues that they raised as part of their submission.
So you're a lot more experienced in dealing with these sorts of situations than I am. Can I just ask you, does the ACCC consider the example provided to this committee by Astoria Honda in Melbourne to be an example of a situation where there is a lack of good faith or action that was unconscionable conduct?
I think, sorry.
Mr. Grease?
So, yeah, I think it's probably not appropriate for us to comment based on the information we currently have, and the fact that the matter's under active consideration by us as a matter raised with us. So it would be best to leave that to our processes to make a more fulsome assessment of the issues.
One of the concerns that I have is how much yellow paper I get from the committee secretariat, and usually that means a confidential submission or confidential documents. Whenever I've had anything to do with the franchising sector, I have reams and reams of yellow paper. That reveals to me how scared so many people are to actually speak up and to challenge their franchisor. And largely it's put to me when I ask people about why they're so frightened, is that they fear retribution from a more powerful agent that their whole livelihood depends on, that they feel that they could lose their home or have their income severely curtailed or be managed out in a way that the code allows. You can't comment, as you've indicated, on the Astoria case, and you've already indicated that you're very much aware of what happened with Holden and you're continuing your investigation. Are other motor traders contacting you like they're contacting us because they're concerned? Or do you think the bridge from where they are to the ACCC is one that's sort of too far for many of these small businesses to actually cross?
I'll answer this first, Senator. I mean, we certainly have had conversations with industry associations, trying to understand some of the issues faced by individual dealers and using those industry or making an offer to those industry associations to hear, further details or complaints or concerns that individual dealers may have, and that's certainly an offer we've made. We do recognise the concern of some of the individuals and the fear of approaching us as the regulator, and we do try to manage that as best we can. But it certainly is a live concern, and certainly is something that dealers have individually said to us about their concerns in making a formal complaint to us as a regulator.
And Senator, I'll underscore that last point. We often don't have difficulty hearing from people or from businesses. It's going on the record that they draw the line at, just for obvious reasons.
One of the concerns that I have is often these businesses are represented by, their fellow competitors, right? They get together and they form a industry group amongst themselves, and then they have a few brave souls who take on the leadership roles, often, in a voluntary capacity, doing advocacy for their fellows. Are you keeping a watch on how those leaders of these industries and the advocates who are standing up through, the AADA and the MTAA are being treated by the principals, by the OEMs? And I guess I'm asking that question because I'm concerned that the civic action that they're taking on behalf of their sector makes them vulnerable to being chastised in some way or having some negative impact on their business because they're standing up for other businesses. Have you watched that space? Have you got any concerns about how power operates with regard to that?
Whenever any of these businesses stick their head up above the parapet, they make themselves a target. And if we become aware that they're being targeted in a way that would be considered unconscionable, we'd certainly investigate that. I can't recall any instances where I suppose a leading business was targeted in that specific way, but I wouldn't rule it out. Obviously, as something that could happen.
And how confidential could a submission to you be if that was the case?
Oh, extremely confidential. As I think I indicated, we have a lot of people speaking to us confidentially who may not ever want to go on the record, but are able to give us intelligence that we can use perhaps in indirect ways. So we always welcome or invite concerned people or businesses to speak to us on that basis.
Some manufacturers considering the introduction of an agent model have indicated that they intend that the agent model for their brand will continue to be governed by the franchising code. Is it the ACCC's understanding that such a model will still be covered by the franchising code?
It will obviously depend on the details of the agreement, but in the main, some of those agreements where it's an agency distribution model will be covered by the franchising code as we understand it, but it does depend on the details of the agreement, Senator. More
likely to stay in than stay out, though, at this point of time?
I think if it meets the general definition of a franchise and all the requirements of a franchise, then yes.
Have you received any reports since you made your submission? You indicated that you hadn't received individual dealers alleging contraventions of the CCA by a manufacturer. Since your submission, has anybody come forward?
There are, I think, a couple of matters that have been raised with us, but they're in very early stages at this point, Senator.
Okay. The instances of clawback by manufacturers as a result of warranty audits on dealers, are you aware of that issue?
Not particularly in the term of that language, no.
Okay, I might give that one on notice. And if I could just go to the draft principles for new car dealership agreements. You're aware of those?
Yes.
We heard from the Department of Industry today that they are facilitating this, that it's not the government's document, it's a facilitated document by them presented to government. What's your view on the development of these draft principles for dealership agreements?
I might start. So I think as principles, they have a lot to commend them. They are very broad, and certainly where you have goodwill on both sides, they would probably work quite effectively as a guiding framework. But I suppose one issue that I would have with them is that you would have to say the devil's in the detail. It would be great to have compensation provisions baked into all agreements, but it's then how they would operate, how they would take into account different circumstances that I think would need some further consideration. So in their current form, I think they are a good start, but I think they perhaps lack some of the precision needed to ensure that the same problems that we've seen previously don't continue to arise.
Would some of your concerns be allayed if there were further details of the kind that you've just articulated, and have that amplified really in a way by making it mandatory rather than voluntary? What would be your preference and why?
So my sense is that, I mean, the detail would be best left to those who have intimate industry knowledge of the practical realities of running the relevant businesses. So it wouldn't be appropriate, I think, for us to comment on that. And look, I haven't formed a view about, I suppose, focusing more on the precision of the principles rather than on whether they should be mandatory. But I suppose if a set of principles that reflected the market reality and sort of were broadly acceptable, then yes, I think becoming mandatory would sort of follow as a logical consequence.
It would make the protections much stronger if this were to be made mandatory.
Well, I think the main issue is whether or not you can find a framework that's sufficiently detailed and sufficiently flexible to take into account different circumstances. I think that would be the first order. As a set of principles, they're great, but I suspect they won't solve the problem in and of themselves.
In 2018-19 MyEFO, the government promised to deliver essentially a standalone auto industry code. Is it time for that?
I'm not sure we're in the best position, Senator, to comment on whether or not it's appropriate for that type of policy response. I mean, we are very much looking at enforcing the law that is in front of us and dealing with those issues faced by businesses.
And I should add too, Senator, that as a whole of economy regulator, we do have a broad but reasonably high level overview of industry. So, yeah, I don't think we're in the best place to determine whether this industry needs its own code or not. Okay.
If I can just ask one final question. You've noted that the ACCC enforcement action for non-compliance with franchise code is an ex post regulatory model that has limited utility in preventing misconduct from occurring. Could you expand on what an ex ante regulatory model might look like?
Well, that would be some form of licensing regime that would, involve a set of regulations and framework for the regulation of behaviours of both sides and dealing with dispute resolutions and ongoing issues as they arise. So it would be an industry framework, whereas in our case we can simply come in after the event and investigate and potentially bring proceedings for breaches of either the code or the general law.
And I think, Senator, I mean, from what we've seen with the franchising code, in general, a lot of small disputes turn into very significant and large disputes. and trying to address or have a mechanism to enable franchisees and franchisors to resolve those issues quickly along the way, whether that's through dispute resolution mechanisms up to, as you discussed earlier, arbitration. I think that's one of our observations with the franchising code more generally, is enabling or preventing those smaller disputes from really escalating and turning to significant full-blown disputes that results in, you know, mediation or arbitration or even court cases.
Would such a model provide effective binding dispute resolution?
That was one of the options that we were considering through the regulatory impact statement process last year, is a way to enable some form of binding dispute resolution, which could be done through a licensing regime, was one of our suggestions, but, you know, it was a sort of a thought process of something that we thought we should put forward as a suggestion for further consideration.
So licensing as opposed to signing on to a code, as we were discussing just at the end of the evidence from Ms Carnell, how would those two things be different, and could they interact together to strengthen support for small business?
I think we'd probably have to consider that in a little bit more detail, but certainly one of the suggestions from the ACCC through our submission late last year was to look at a way in which we could, you know, create a series of standards and then to have dispute resolution linked in with those standards. So that was the suggestion that we put forward through that process.
Thank you. Yeah, I'm finished. That was my last question. Very good timing,
Perfect
Chair.
timing. Thank you. Cheers.
Thank you, Chair. Thank you.
Very much.